Hello, I am Suzanne from Corrido.eu. Today we will talk about how to write a good employment agreement. In this video, we will provide a step-by-step guide on how to write a good contract, what to include, and how to structure the document. An employment agreement is a legally binding document that outlines the terms and conditions of an employment relationship between an employer and an employee. It is a crucial document that sets out both parties' expectations and responsibilities and helps minimize misunderstandings and potential disputes. Step 1. Determine the type of employment relationship. Before you start drafting the employment agreement, it is essential to determine the employment relationship between the employer and the employee. This will largely depend on the nature of the work being performed and the length of the employment term. Some common types of employment relationships include full-time. A full-time employee typically works a set number of hours per week, for example, 40 hours, and is entitled to benefits such as vacation time and healthcare. Part-time. A part-time employee typically works fewer hours per week than a full-time employee and may not be entitled to the same benefits. Temporary. A temporary employee is hired short-term to fill a specific need or to cover for an absent employee. They are generally entitled to different benefits than full-time or part-time employees. Step 2. Identify the parties involved. The next step is to identify the parties involved in the employment agreement. This includes the employer, such as the company or organization offering the job, and the employee, such as the person hired to perform the work. It is important to state both parties' names and contact information in the agreement and any relevant legal entities, such as a parent company or subsidiary. Step 3. Establish the term of the employment. The term employment refers to the duration of the employment relationship. This can be a specific period, for example, 1 year, or it can be ongoing until terminated by one of the parties. In addition to specifying the term of the employment, it is also important to include provisions for renewing or terminating the employment. For example, you may want a clause that allows either party to terminate the employment with a certain amount of notice, for example, 30 days. Step 4. Outline the job duties and responsibilities. It is essential to clearly define the job duties and responsibilities of the employee in the employment agreement. This includes the tasks or responsibilities the employee will perform and any reporting or supervision requirements. Including any relevant job titles or descriptions in the agreement is also a good idea, as this can help clarify the employee's role and responsibilities. Step 5. Specify the compensation and benefits. The employment agreement should include provisions outlining the employee's compensation and benefits. This might include the employee's salary or hourly wage, any bonuses or commissions, any benefits such as healthcare or retirement plans, any paid time off such as vacation time or sick leave. Specifying the terms of compensation and benefits clearly in the agreement, including how and when they will be paid or provided, is essential. Step 6. Address any potential liabilities. An employment agreement should include provisions addressing potential liabilities due to the employment relationship. This might include a clause outlining the employer's liability for any damages or losses resulting from the employee's actions or stating that the employee assumes all risk for any damages or losses. Step 7. Include any relevant terms and conditions. Some standard terms and conditions that might be included in an employment agreement include the following. Confidentiality provisions outline the obligations of both party business information confidential. Intellectual property rights. These provisions outline who owns any intellectual property, such as patents, trademarks, or copyrighted material, created or used during employment. Non-compete clauses. A non-compete clause prohibits the employee from working for a competitor or starting a competing business during or after the employment relationship. Governing law. This clause specifies which jurisdiction's laws will govern the interpretation and enforcement of the agreement. Step 8. Review and revise the draft agreement. Once you have drafted the employment agreement, it is essential to review and revise the document to ensure that it accurately reflects the terms and conditions of the employment relationship. This might involve soliciting input from legal counsel or other stakeholders or reviewing the agreement against industry best practices or standards. Step 9. Have the agreement reviewed by legal counsel. It is generally a good idea to have an employment agreement reviewed by legal counsel before finalizing it. A lawyer can help to ensure that the contract is legally enforceable and protects the interests of both parties. Step 10. Finalize and execute the agreement. Once the employment agreement has been reviewed and revised, it is time to finalize and execute the document. This typically involves both parties signing and dating the agreement and possibly exchanging copies or original signed copies. An employment agreement is a crucial document that outlines the terms and conditions of an employment relationship between an employer and an employee. Following the steps outlined in this video ensures that your agreement is clear, comprehensive, and legally enforceable. We hope this video has helped provide a comprehensive guide on how to write a good employment agreement. Feel free to let us know if you have any additional questions or need further clarification on any of the points covered. If you need professional advice in the field, we have the right consultants to help. You may view the services that we can offer through corrido.eu.